moving for them. They don't forget it.
Right. Mr. Reddington, what's your message to all these folks who are here today?
Thank you. That's all I can say. It's amazing.
We love you, Kevin.
Kevin, are you surprised at just how much attention this case has gotten? I mean, people are coming from Maine.
It's the message. It really is. It's the message that just has reverberated, throughout the whole country.
What is that
Reddington's
message?
fighting for women's rights.
No, I
for
don't.
healthcare.
I think that it's the mental health system. I hate to use the word health care because unfortunately in this case we can see it hasn't been health care, and I think that it shines a light on this issue. I mean, when a woman is going through what so many people do, and they go to a doctor, and the doctor says, here, take this pill, take that pill, take this pill, and then they basically treat them for 15, 20 minutes and send them on their way. It's just not right.
And to those who can't wrap their heads around sympathizing with a mother who killed her 3 children, what do you say to them?
I think it's almost like when you're picking a jury, and sometimes somebody will say, well, I don't agree with, this allegation of murder. I mean, none of us do. But that's what we have juries for. They pass between the government and a defendant to see if they can prove their case.
What do you think? Aware of this support, and what does she think of this?
I'm going to go in and see her right now. I'm sure that she is, and if she isn't, she will be.
What do you think about?
She's so beat up and just so sad. This will really help her out, I think. It's awesome.
Tell her we love her.
What do you think about you being the advocate for all women right now?
I'm not an advocate.
You are. But you are. But you are.
Thank you, that's live in the action.
Yes.
Before the court today, we have a continuation of the jury trial matter Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Buckingham.
All right. Thank you, Madam Clerk. Good morning, everyone. Nice to see you again. I know I just spoke to you probably about 10 minutes ago. But again, I want to ask you those questions, then we'll talk a little bit about what our schedule is today and for the rest of the week. All right, so first question, has any member of the jury read, seen, heard, or overheard anything from any source about any aspect of this case that would affect your ability to be fair and impartial as a juror? Next, is there any other serious matter or concern bearing on your service as a juror that anybody needs to bring to my attention at this time? All right, again, thank you for following those instructions. And then in regards to our schedule today, you're allowed to kind of roll your eyes because I'm going to say we're going to have kind of a short day today. All right. And that is, as I talked to you yesterday about an issue that has nothing to do with any of the attorneys in this case. All right. It's just something we're going to work out, and I anticipate it will be worked out so that tomorrow you should count on a lengthier day. All right. I've talked to counsel earlier this morning in regards to where we are in regards to the schedule and the timeline. We are still, if not on schedule, still ahead of schedule. All right. And this delay that we may have a little bit this afternoon won't affect that. All right. So I just kind of wanted to let you know that I appreciate. I know you came in here this morning. It's going to be a short day, but also gear up for a longer day tomorrow. Okay. And so with that, the other thing is I told you it's got nothing to do with any of the attorneys, but it's also or the parties. So you're not to speculate about what this might be. It's also you're not to hold it against either of the parties in regards to this. All right. If you're going to hold it against anybody, you can hold it against me. All right. So with that, we're going to return now to the evidence in this case. And Attorney Reddington?
Thank you. Sheila Kavanaugh, please. Let's say.
Good morning. Just face, Madam Clerk, raise your right hand, please.
So that the testimony of the evidence you shall give to the court, sorry, the matter not coming between the Commonwealth and the with the whole truth and nothing but the truth.
Yes.
Thank you. You can have a seat.
Just watch your step right there.
All right, well, good morning.
Good morning, Your Honor.
All right, I just ask you to speak into that microphone and keep your voice up so the jury can hear you. Attorney Reddington.
Thank you. Good morning. Can you tell us your name and spell your last name, please?
My name is Sheila Kavanaugh, Cavanaughh.
And what town do you live in?
I live in the town of Belmont, Massachusetts.
And what are you doing for work now?
I am a board certified chaplain at Brigham and Women's Hospital in Boston.
And I didn't know that there were board certified chaplains. What does that mean?
Well, to become board certified, you need minimally a master's degree in theology or divinity. You need to complete 1,600 hours of training post your master's degree. 1,200 of those hours are occur in a clinical setting, and 400 of those hours are in a classroom setting where we study various disciplines: psychology, sociology, philosophy, theology, and ethics. Beyond that training, we need to acquire 2,000 hours of additional clinical training before we can even apply for board certification. And we have to demonstrate mastery of 30 competencies before we go to a national board, and they make the assessment. I also need an ecclesiastical endorsement, and in my case, that was from the Archdiocese of Boston, from Cardinal Sean O'Malley.
And before you obtained the board certification in your education to allow you to be a chaplain, what did you do for work?
Prior to becoming a chaplain, which is a second career for me, I was a senior vice president at Fidelity Investments in Boston.
And how long were you senior VP at Fidelity?
16 years.
And are you married?
I am.
You have a family?
I do. My husband and I are the parents of 4 adopted children. When I was pursuing my master's degree at Boston College, it was a 3-year master's, but it took me 5 years because we adopted our 4th child while I was in graduate school. She was a 14-year-old girl from Bogota, Colombia.
And how long have you been working now as a chaplain at Brigham and Women's Hospital?
7 years.
In the course of your duties as a chaplain at Brigham and Women's Hospital, did circumstances bring you in contact with Lindsay Clancy?
Yes, they did.
Can you tell the jurors what happened?
I arrived on the morning of Wednesday, January 25th, 2023. I arrived at approximately 8:30 that morning because I was there to relieve the overnight chaplain who was carrying the pager. I was taking over the pager shift, which went from 9 to 1 p.m., although I was working a full day. When I arrived that morning, she said to me, "Did you hear the news?" And
Sustain.
okay.
So you can't, you got to object, so you can't say what someone told you, okay? That's
Oh,
called hearsay.
okay.
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 So I can say, as a result of a conversation with that person, what happened?
I was summoned to the director of spiritual care's office,
Did
and
you have a conversation with her?
I did.
All right. And as a result of that conversation, what did you do?
I went to Unit 8C in the Tower building of Brigham to meet with Lindsay Clancy.
And what time of day was this?
Roughly between 8:30 and 9:30 that morning.
And when you went in to see Lindsay, what did you observe?
Well, the unit itself was filled with law enforcement officers, both outside the doors of the unit. There was Brigham security, but the unit itself was flooded. There were people from Plymouth County, Boston City Police, Brigham Security. So I had to make my way through concentric circles of law enforcement to even get to the room. I was permitted to see Lindsay, although she could not speak at that time.
And what was her condition that you observed?
She was dressed in medical armor. She had tubes. She was intubated. She had bandages. She had a neck brace. She was just covered and layered in equipment that enabled her to breathe.
Now, I'm showing you Exhibit 121 and asking, this may be South Shore or it could be Brigham and Women's, but is this indicative of what she appeared to be when you first saw her?
That looks like it's from South Shore because when, yes.
Does she have the same?
Similar.
Very similar?
Very similar.
That?
Yes, very similar.
Did you see her again on another date?
I did. I saw her the next day. Again, she could not speak. She was intubated as well. That was the first week that she was hospitalized.
When was the next time that you saw her?
The next time I saw her was the following week. I have a calendar here of my visits. I saw her on Tuesday, January 31st, and she had been extubated at that point so she could speak.
So the tube had been removed. She was able to communicate, and that was on January 31st?
I believe she was extubated the weekend of the 28th, but I didn't work that weekend, so I saw her on Tuesday, the 31st.
All right. Tell the jurors what you observed and what, if any, conversation you had with Lindsay on the 31st. And let me ask you, how long had it been that they removed the tube?
Perhaps a day or two.
A day or two. Okay. Tell the jurors what she said to you.
She continued to look like the photograph you just saw. She was covered, tubes everywhere, the neck brace. Her emotional state was very neutral, a flat affect. But I remember vividly the first thing she said to me. Now, she had heard me for a couple of days. We had been praying together. And so when I went in on Tuesday, the 31st, she said to me as I held her hand to comfort her, "I am so glad my children are safe."
Was there any other conversation that you had with her?
I replied theologically to Lindsay, and I said, "Lindsay, your children are safe. They're safe in heaven with God." And I held her hand throughout that conversation, and we prayed for them.
Did she make any other statements to you?
She did. She alluded to having heard a voice, and the voice, according to Lindsay, told her that if she did not follow the command, neither she nor her children would be safe.
And did she indicate whether it was a male voice, a female voice, loud, soft?
She alluded to the fact that it was a male voice and it was persistent.
Any further conversation that you recall about that, not about general things,
That came up several times. I visited Lindsay minimally 14 times while she was hospitalized at the Brigham, and the voice conversation came up several times during several of our visits.
Now, after Lindsay was transferred or cleared to go from Brigham and Women's Hospital, did she go to another facility?
She did. She went to Spalding Rehabilitation Hospital.
And do you know when that was?
That was roughly late February, perhaps around the 23rd.
And did you continue to see Lindsay at Spalding Rehab?
I did.
Do you know when she left Spalding Rehab?
In the late March, early April time frame, perhaps.
Okay. Now, Brigham and Women's Hospital and Spalding Rehab are under the same umbrella of hospitals. Is that right?
They are. So Brigham and Women's Hospital and Spalding Rehab are under the Mass General Brigham complex. So for me to visit Lindsay in Spalding, I was still within the same hospital complex, and her psychiatrist at Spalding, as well as the chaplains, advised me to continue.
You can't say what anybody told me.
Oh, sorry.
So when she was discharged from Spalding Rehab, where did she go?
She went to Tewksbury State Hospital.
And fair to say that that would be back around February. It's been a little more than 3 years, 3.5 years.
Yes.
Is that correct? Now, when you saw her in Spalding Rehab and in Brigham and Women's, you were acting in the course of your job. Is that right?
That's correct.
So you're being compensated, you're getting your paycheck and that type of thing. Right?
Yes.
How many times have you seen Lindsay at Tewksbury Hospital?
Perhaps 200 times.
Tell the jury why you continue to see her for 200.
Sustained.
So can you tell us how often on a weekly basis you would see her at Tewksbury?
Yes. When Lindsay was admitted to Tewksbury State Hospital, I continued to see her on a weekly basis. We had built up a very comfortable, respectful rapport, and I felt it was in her best interest to continue that as she healed. She was still in deep grief. She was suffering.
Sustained.
So
That opinion be stricken.
So did she express anything about her children and their loss over that period of 200 times that you saw her thereabouts in Tewksbury?
Objection.
No, overruled.
Yes.
Other jurors?
Lindsay talks frequently about her children. She loves them deeply. She carries immense grief.
Objection.
Overruled. Next question, though.
And has that continued to your observation?
It continues presently.
When was the last time that you saw Lindsay in Tewksbury?
Just prior to the trial starting.
Thank you very much. Appreciate it.
Thank you.
All right, Kamala.
Thank you. Excuse me. Good morning.
Good morning.
You were talking about on January 25th, 2023, when you first saw Lindsay in direct examination, and you said that there were a lot of police officers in the area, correct?
Correct.
But you mentioned that some of them were security personnel from the hospital, correct?
Correct.
And you're aware that the security personnel for the hospital don't work for the state police, the Tewksbury Police, or the Plymouth County DA's office, correct?
Correct.
So they're separate and apart from law enforcement, correct?
Yes.
And then are you also aware that on January 25th, 2023, there was a search warrant being executed to collect evidence from the defendant and from the belongings that she had at the hospital?
No, I was not aware of that.
Were you aware that that collection of the search warrant required state police and personnel from the crime lab to be present for the collection of evidence?
I was not aware of that.
Were you aware that following that, at any given time, there were only 2 officers, either Tewksbury Police, State Police, or Plymouth County Sheriffs, at her room, the defendant's room, at any given time?
I do recall that.
And they were stationed outside of her room, correct, in the hallway?
Yes.
So that the only time you saw this large amount of officers present was on the 25th, when there were security from the hospital and search warrants being executed, correct?
Perhaps.
Okay. Now, you mentioned that on January 31st, 2023, you spoke to the defendant and she told you that she heard a voice telling her that if she did not follow the command, neither she nor her children would be safe, correct?
Correct.
You wrote very detailed notes that are contained in the Brigham and Women's Hospital records regarding your interactions with Lindsay Clancy, didn't you?
Yes, I did.
And in all of these notes that detail every time you interacted with her, you never once wrote that she told you she heard a voice or what that voice said, correct?
Correct.
And you also said that this voice, talking about the voice, came up in several of your meetings, correct?
Correct.
And you never once wrote about any of it in any of your very detailed notes, correct?
Well, chaplain notes are not verbatim transcripts of patient conversations. I'm not there to evaluate the patient. I'm there to bear witness to their suffering.
Okay, but the question was, you did not document those statements in your notes, correct?
Correct.
But you did document some other statements in those notes, correct?
Perhaps.
For example, on February 6th, 2023, in a note that you wrote regarding your interaction with the defendant, you said that, or you wrote, Lindsay welcomed the visit and shared her fears of, quote, not being able to walk again, end quote. She continued to express her fears of how her inability to walk may make her vulnerable to others in the future. Do you recall writing that?
Yes.
Do you recall writing on February 9th, 2023, that the defendant was sitting in a chair adjacent to her bed and appeared to be visibly engaged, energized, and hopeful than in previous visits? Do you recall that?
Yes.
You also wrote in that note, Lindsay spoke hopefully of being discharged when the time arrives to Spalding, correct?
Correct.
And then in February 13th, 2023, you wrote in your note that Lindsay also expressed hopefulness in relation to her physical progress. She feels she has gained considerable physical strength and agility despite an inability to move her legs. She admitted that she feels, quote, deserving of this, end quote, in light of recent events. Do you remember writing that?
Yes.
Do you remember on February 16th, 2023, that you wrote in a note that the defendant expressed hopefulness with the news of her anticipated discharge to Spalding and seemed uplifted that she would be cared for in a facility with an excellent reputation?
Yes.
Do you recall writing on February 16th, 2023, that Paula, the defendant's mother, and Lindsay, the defendant, were playing a card game as they communed quietly, and that Lindsay expressed hopefulness with the news of her anticipated discharge to Spalding and seemed uplifted?
Yes.
And again, you've got all these details about her feelings and her thoughts and what she's doing, but nothing about the voices that you spoke of so many times, correct?
Correct.
And speaking of Spalding, you continued to visit her at Spalding, correct?
Yes.
In those conversations with her at Spalding, did she tell you that how in those first weeks at Spalding, that part of her physical therapy, she was working out with a yellow exercise band? No?
I don't recall her telling me that.
Did she tell you that during that time at Spalding, she reached out to a social worker there and asked for help filling out SSDI paperwork to get an income?
That would be beyond the scope of our conversation.
She didn't tell you those things?
No.
Thank you.
So, counsel has asked you about her filling out a form for SSDI. Were you aware of what expenses her family and were incurring as a result of her physical incapacity, paralysis, and being in the hospital?
From my experience with thousands of patients, I had a very clear idea of the enormous expense.
There's a difference between, as the district attorney very appropriately referred to, that your comments were about her thoughts and her appearance and her feelings. Is that correct?
Correct.
There's a difference, however, between privileged communications with a chaplain and observations of a person's feelings and thoughts, correct?
Correct.
Tell the jury what effect privileged communication has when someone talks to you personally as a chaplain.
Because I'm not a medically trained clinician, I approach patients in a vortex of trust. Some of our chaplains at the Brigham are ordained clergy. And so there's this understanding that when a patient interacts with a chaplain, the conversations are confidential.
Do you put them in medical records?
No.
The words, like Lindsay indicated that she felt uplifted, I think the counsel read that twice. Were those your notes, or is that what she said to you? Did she say, I feel uplifted, or is that
That
your
was my
observation?
perception of Lindsay. It was not her words.
Thank you.
Thank you.
Como?
You said you're not allowed to put the defendant's words in your medical records. Is that correct?
No, that's not correct. It's not that I'm not allowed. It's an understanding, and it's a conversation that's held in confidence with the patient.
Then why are there direct quotes in these medical records from the defendant?
Well, they're not verbatim transcripts.
No, not a transcript of the whole conversation, but you put phrases in quotes. For example, on February 6, 2023, where it says Lindsay welcomed the visit and shared her fears of, quote, not being able to walk again. So those were her words in your note, in quotes, in the medical record, correct?
Yes,
Thank
yes,
you.
I use my best judgment.
Okay. I would move to have these submitted as the next exhibit, the notes of the witness in her interactions with Ms. Clancy at the Brigham and Women's.
Any objection?
No.
All right. They may be admitted.
I have no further questions. Sorry.
Hey, Mr. Reddington, go ahead.
I have no further questions. Thank you.
Okay, thank you.
All right, thank you. You may step down. All right, counsel, can I see you? told you it was going to be a short day for you, right? And I appreciate your patience with us. So I'm going to excuse you till tomorrow at 9, all right? Same instructions. And that includes reading anything, talking about this case, watching anything. Just don't do it, all right? And when you leave here today, just drive, go home, wherever you're going to go, and plan on being back here tomorrow morning at 9 o'clock. The plan would be that it will be it will be a longer day than today. I appreciate you coming in here today. We moved the case a little bit today, and I appreciate that. So we're able to do that. So I hope everybody has a nice afternoon and evening. We'll see you tomorrow morning for a longer day. And just remember those instructions from the moment you leave to the moment you come here tomorrow. Okay? Again, thank you so much.
All rise, please. Your next meeting. The court will close the session. Please be seated.
All right. So what we'll do is we'll take a short break at this point. We'll come back. We'll do kind of a preliminary charge conference. We're going to just, I know council knows, but for everybody else, discuss possible jury instructions, suggestions from council. Then we can talk about any logistical issues that we have for tomorrow. And then we'll probably recess at that point. All right, so this will be a short recess, and we'll come back up. Thank you.
Court, all rise.
All righty, squad. Wow, very short day. He did indicate to the jurors that this has something to do with one of the parties, which means it's an issue that has to do with either side of the case. It is not a juror issue. The judge did say to blame him. I've heard judges say that many times. They say that so that they don't take it, so that the jurors don't take it out on either the prosecution or the defense. But there's something going on with one side or the other. Reddington looked real pissed when this happened yesterday, which makes me think it has to do with the state. But I don't know that to be for sure the case at this point. We don't know exactly what's happening. The defense has not rested, however. So maybe it is one of their witnesses. I don't know. There's just no way really to predict it. There's tons of, we can have tons of speculation, but it sounds like there's an issue on one side or the other that is something that they can't do anything about. So court will be back tomorrow. Today was quite a day. As you see, I'm wearing my pink for Lindsay. There was a huge demonstration in front of the courthouse this morning of supporters of Lindsay and Reddington, all wearing pink. We heard just a little bit of what Reddington had to say at the beginning of this live stream. If you go on Court TV, there's a huge long thing, and they talk to various women and stuff. It's really, really cool. And I would encourage you to check that out. It's amazing. They are on break right now. I need to double check and see what they're going to do now is jury instructions, which is interesting to me because so they are going to come back here in a minute. Well, not in a minute, but I will take us back. in a minute so that we can witness that. But no more witnesses for today. How do they keep jurors from not seeing the online super sleuths? Because it is their word that they are staying off from social media. They are required to stay off social media. It's part of the deal. And it's just what they have to do. I've heard from jurors in the past that when they've been on a trial like this, that they read a lot of books because they just go totally analog to avoid everything. And that's just part of our legal system, that we have to trust the word of the jurors. And they've been given, you see the public side of it, the admonition they're given by the judge. They're also given private admonition as well. I did hear that they were questioned specifically about today's demonstration. And questioned about if they saw that and how it impacted them. And there is a question, Bethy. Where is Patrick? Patrick is not in court. Was Patrick supposed to testify on behalf of the defense? I assumed he was. From his prosecution testimony, I assumed he would be here for the defense as well, just like his mother. But Patrick's not around. And so maybe this has to do with Patrick not showing up. Maybe Patrick's going to piece out of this situation. I would imagine he's feeling pretty vulnerable, considering that the entire internet thinks that he is the one that committed this crime and not Lindsay. So I don't know. We'll see what's going to happen here with all of this. But this is how watching a trial goes, You never know what's going to happen. You really never know what to expect. They go the way they go. Yeah. So the hot mic moment, which I need to go back and find. I don't have it pulled out of the audio, but yeah, is this because Patrick's not around and he was supposed to testify for the defense? I have wondered that, because I really did think he would, considering his prosecution testimony was in support of Lindsay. But at this point, he's probably feeling very vulnerable because he's being blamed, whether he did it or it's his fault because he didn't help Lindsay enough or he left her with the kids or whatever. There's a lot of that going around right now. So that could be, but that is also speculation. So we'll see what's going to happen. I did want to address the chaplain who validated the theory that I put to you yesterday, which is that Lindsay saw the voice that she heard telling her, listen to these words. She must kill her children and herself or they would not be saved. Saved. That means they're not going to go to heaven. Right? I mean, in very basic terms, they would not go to heaven. So Lindsay, in her very mentally ill state, may have perceived that voice as the voice of God telling her what she had to do. Now, has that happened before? Yeah. Many, many, many times across millennia have human beings done terrible things because they thought God told them to. Now, religious people tend to see that as a spiritual experience and not a mental health concern. Because, they're all mad she didn't tell her counselors about it and her doctors. She told a chaplain. And she now has a priest who talks to her every day. And that chaplain is still seeing her now at the hospital she's in. Why? Because she thought this was a religious experience. It is a very common experience in psychosis. And if your upbringing tells you that at some point God might talk to you and tell you what you have to do, I was taught that as a Mormon kid. I was taught that at some point God might tell me what to do, and that I was to do it, or that Jesus might tell me what to do, and that I might do it and I would have to do it. Yeah. How many of you had that experience in your upbringing? Now, as an ex-Mormon and a social worker, I recognize that to be mental illness. But depending on a person's upbringing, that is not necessarily the case for them internally. And who did Lindsay tell? She told a chaplain. Telling you, I think this is what happened. She was hallucinating and delusional, and she was experiencing an experience that she was taught as a child might happen to her, and that she listened to God because God said, if you don't kill your children and yourself, you won't be saved. She may still believe that she and her children, she did say at least her children are safe, but she may still believe that she won't be saved because she didn't die. It's very difficult to turn those beliefs in someone who is mentally ill and experiencing that kind of command hallucination. It's pretty tough to compete with God. I think we write down to the nitty-gritty of what happened in this case. I think it's really, really important. Yeah, many of you are validating this, as well as saying that the religion you were brought up in didn't teach you that. And so if you weren't taught that as a child, you might, if you were to have this experience, you would be afraid of it. You would think that it was something bad is happening to you. But what if you were? What if that was a part of your belief system? I think it's a really valid question. Right. Unalive doesn't get you saved. Right. In rationality, sure. We got to remember, Lindsay was not rational. Lindsay's ability to determine reality was broken. She couldn't reality test. She couldn't tell the difference between what was happening in her head and what was happening in reality. It's a really, really important element of mental illness. When you lose the ability to tell the difference between what's real and what isn't, you're in a very dangerous and vulnerable state. Very clearly, that's what Lindsay was experiencing, as far as I'm concerned. But the kids were still innocent and would go directly to heaven. What if God told you otherwise? And in a state where you were unable to reality test to determine what was real and not real, would you save your kids? It's just something to consider. Because remember, those voices, and this is the line. This is the line in mental health. Because mental health acknowledges religious and spiritual experiences. If the voice tells you to do something that is harmful to yourself or someone else, that is mental illness. But that doesn't mean that a person who is unable to reality test knows that. It's really important. Right. Catholics don't believe in cremation, but I don't know if Catholics believe in cremation or not. But the decisions made around the children were made by Patrick, not by Lindsay. So remember that we're all looking at this from a rational state of mind, but we know Lindsay was not in a rational state of mind. I think it's pretty powerful stuff. Irene, okay. Catholics do cremate, okay. See, Mormons for a long time didn't either, but it was kind of more cultural than theological, and there are a lot more Mormons that are cremated now than used to be. It was never like doctrine when I was a Mormon. I haven't been a Mormon since I was 19, but there are so many questions in this case, so many more questions than answers, even as we are coming to the end of this trial. One of my big questions right now is, what about the prosecution's rebuttal? Do they have a doctor to rebut Dr. Zeizel? Yesterday, Reddington said, and he made a bunch of statements about the doctors that got stricken. But basically what he said is that it took them a really long time to have Lindsay evaluated. And one of the problems was that the evaluators agreed with the defense's doctor. Now, remember, when we talked about LaTarsha Sanders last week, that is exactly what happened in the LaTarsha Sanders case. The state did not put on their evaluator because their evaluator agreed with the defense's evaluator that LaTarsha Sanders had experienced the onset of schizophrenia. And if you recall, LaTarsha Sanders also had religious hallucinations and delusions that were tied to the reasons for her killing her children. The state didn't even put on an evaluator. And the reason they didn't is because the evaluator agreed that she was not criminally responsible for what she'd done due to her mental health. Important stuff. I think this is very important. I hope, upon hope, that Red clarifies this very clearly to the jury in his closing. Who Lindsay told and what that might mean. I want you to know I put my Venmo up on the screen. I've had requests from some of you. This channel is not monetized currently, but there is a way to tip me. It is Venmo. My Venmo is just my name at Christy Brower, KRISTI BROWER. Tips are much appreciated. I may look tired to you, and that is because I am. This is day 17 of this trial. This has been grueling. I'm very glad I'm doing it. I don't regret it at all. And tips are never required, but they certainly are appreciated. If you can drop me $5 for a cup of coffee, I would appreciate it a whole lot. And going forward, I'll continue to publicize my Venmo as a way to tip for this channel. Okay, well, I know that they do go back live with the judge, with the attorneys. They're going to work on jury instructions. I had my infusion on Tuesday. Yeah, and that's kind of a hard week for me. I'm a little tired, more tired during the week that time. So, but this case matters. It matters so much. You saw those demonstrators this morning. Having a man stand up genuinely for women's health and women's mental health is so powerful right now because we've lost a lot. And we never had that much to begin with. There is more money, significantly more money spent on research for erectile dysfunction in men than there is spent on all of women's health. That's insane. And it needs to change. And the reason why cases like LaTarsha Sanders, Lindsay Clancy, Andrea Yates happen is because we don't have the research. We don't have the support. We don't have people that look at Lindsay Clancy and go, we know exactly what to do for you and how to help you to keep this from ever happening again. And yes, shout out to Ashley for from the chat. She was there at the demonstration this morning. I'm so jealous. I'm in Idaho, guys. I'm a long ways away. So I couldn't go, but thank you for going and representing us, Ashley. Very much appreciated. All righty, I'm going to pop off from here and let's go back and see what's going on in the courtroom. You know it. I'm Christy with True Crime Squad Trials. Thanks for being here.
parties at Plymouth, excluding the 18 jurors.
All right. All right, counsel, what I kind of wanted to do is at least have a preliminary discussion regarding instructions. And what I would generally do is after we have the discussion is then kind of distribute a draft to council so everybody we could have a more focused charge conference next day or so. But I just kind of wanted to get everybody's thoughts or kind of suggestions that they would be seeking the court to instruct the jury on. So kind of what I'll be using will be the model jury instructions, generally the model jury instructions from the March 2026, the latest suggestions from the SJC. And so Commonwealth, let me kind of hear what your thoughts are, and then I'll hear from the defendant.
So for individual instructions, we have listed opinion testimony, prior inconsistent and prior consistent statements, redactions. I don't think there are too many, but there were some on the death certificates, stipulations and consciousness of guilt instruction. In terms of what we're looking for for the charges, we'd be looking for an instruction on first and second, with the theories of first being both deliberate premeditation and extreme atrocity and cruelty. In terms of the criminal responsibility instruction, we're asking that the instruction regarding intoxication not be given, because from our perspective, there's been no evidence of intoxication by drugs and or alcohol during the killings. There's testimony, and I think there'll be more testimony about the defendant taking pills after killing the children, and before killing the children, she was on low-dose prescription, 10 milligrams of amitriptyline that was recently increased to 20 milligrams, but there's no real evidence of whether or not she actually increased that dose. And then it was a low dose of trazodone and a low dose of, I believe, Valium. So those were prescribed medications that she had reported no side effects from. And I believe in the text with her mother, she said that she was still waiting to actually feel effects from those. So there's no evidence of intoxication from those drugs. And then the only intoxication potentially could be when she took pills after killing the children. And even those amounts from the toxicology are low-level amounts. So we're asking that the instruction on intoxication not be given.
Let me ask you this. I'm going to ask the defendant as well, because I did read through those. And I was trying to find the definition of intoxication as it applies in the homicide instructions. Most of the cases that I was able to find so far is the dealing with the OUI statute, Chapter 90. And trying to find the real definition in regards to that. Is it the Commonwealth's position that the intoxication is beyond what was the considered effect of the drugs? Because if you know what I'm saying? So if she takes, if a defendant, I don't mean to personalize it, if a defendant takes prescription drugs and it does create some effect, would that be considered intoxicated for the instruction?
I don't believe so. I think in the instructions, it talks about having being intoxicated to the point where it affects your state of mind or ability to control yourself. I think intoxication, especially where there's not a specific definition given in the homicide instructions, I think you go to the general definition of intoxication, which would not just be taking medication as prescribed, but it would be over taking medication or combining with alcohol or other drugs. Is similar to the instructions in OUIs, operating under the influence of alcohol or drugs. I think you would have to go to that definition or to the general definition of intoxication if it's not specifically defined in the instructions. And I think the general definition of intoxication is taking some type of substance, either alcohol, drugs, medication, in excess, and to the point where it's affecting your ability to think and to act and to control your behavior.
All right. All right. Anything? So I've got opinion, prior, consistent, prior, inconsistent, redaction, stipulations, consciousness of guilt, first, second, extreme atrocity, deliberate premeditation, and the criminal responsibilities without the subparagraph, the paragraph regarding intoxication.
Correct.
Okay. All right. Mr. Reddington?
I don't know if the government has been listening to the same evidence in this case. This is clearly an involuntary intoxication defense, at least as far as the judge's charge to the jury, based upon the evidence that's been presented, whether or not it's what we would argue is the over prescription of the medications, whether or not it's the side effects of the medications, whether or not it's the titration or the termination or the immediate cessation of the medications against what normal medical advice would be. All of those factors contribute to the state of mind of Ms. Clancy that was expressed to a lot of people, family members, people that knew her. She had indicated, I think Your Honor knows the evidence, repeatedly indicated that she was affected by the benzos. She was felt that she was being addicted to the benzos, trying to get off the benzos. She indicated that the sertraline was obviously killing her as far as going from 25 to 50 milligrams. And then subsequent to that, when there's additional SSRIs prescribed, to suggest that there's no basis to give the jury the instruction, they may determine based on the evidence that is as a result of the involuntary intoxication from narcotics, not alcohol, obviously, from the prescribed narcotics, not illegal drugs. So from the prescription drugs, that's on all fours with a valid defense that they should be instructed as it relates to involuntary intoxication. I think it's the model jury instructions on criminal responsibility. Obviously, if there's any nuances that I would pick up, I would bring that to the court's attention. But I have tried murder case recently with the model jury instructions, and my memory is that I was pretty satisfied. It was Judge O'Shea, I think, actually in this courtroom a year ago, and I was satisfied with the instructions on lack of criminal responsibility. I would, at some point, ask the court to charge on involuntary manslaughter. I'd ask the court to charge on wanton conduct with a component of the impact of the intoxication. So you can't try this case in a vacuum. You can't present the case to the jury. I know the government would like to present the case only on cruelty and atrocity. They probably don't like the statute that allows a jury to determine the degree of murder, which would be first and second. But I think that the evidence is such that a jury should have the option of considering whether or not we're talking about involuntary manslaughter based upon the evidence that's permitted. So I would defer to the court on the instructions on cruelty and atrocity, premeditated malice aforethought, second degree malice. I would ask the court to consider instructing on involuntary intoxication, to consider on the involuntary manslaughter as a lesser offense, and anything else that I can think of. But right now, that's what I can think of.
All right. Yeah, counsel.
Thank you. Commonwealth did request first and second degree instructions. It's our position that involuntary manslaughter wouldn't apply here. The evidence is that there was a specific intent to cause the death. So there's nothing that I can think of in the involuntary instruction that would apply here. Going back to the intoxication just for a moment.
Sure.
All of the medications, most of the medications that defense counsel talked about that the defendant was having reactions to and side effects from were before her hospitalization at McLean Hospital. And she was weaned off of that last one, the Seroquel, that while she was in McLean Hospital, and then she was without those medications and they're out of her system for 3 weeks, and she's just on those other 3 medications. So the intoxication that matters is not what happened in the fall and before McLean, it's what happened on the day of the incident. It's similar if it's an OUI, it doesn't matter if you were drunk in November, it matters if you're drunk on the date of the incident. So what matters here is that January 24th, 2023, and those other drugs and the effects that they caused to her aren't relevant to what happened on that day, as they've been out of her system for at least 3 weeks at that point.
All right, so the Commonwealth's position would be that the relevant analysis is what she was taking on or around that January 24th?
Yes.
Okay, all right. All right, any other?
Yes.
Yeah, good, sure.
It occurred to me, again, as I said, it's only fresh in my mind from the case I had here last year. I know the model jury instructions indicate, and I'm trying to find it in here, that there's supposed to be consideration of a chalk for the court to write out the elements of the offense of first-degree murder, cruelty and atrocity, premeditated malice aforethought, etc. And I would ask that you not do that. I don't think that it's appropriate. I think it highlights, if you will, in simplistic terms, premeditated malice aforethought. I think you and I, we just had a murder case last year on another matter. And I mean, I heard your instructions. You're very forceful with the elements of the offense. And I just don't think we need to have this appendix or whatever you want to call it. And again, I did object to that with the Judge O'Shea. We did not submit the instruction list, cookbook, or whatever you want to call it, to the jury. So I think that the court's instructions would be sufficient. I would not want to have that chalk that is referenced in the model instructions. That's discretionary. It's not obligated. They just say that it might be helpful for the court to give the jury some type of a checklist. But I don't think we should reduce instructions on a murder case to a checklist. And I'm just afraid that what happens is that jurors then take the checklist, as it were, and they kind of look at it or consider it, and they just do exactly that. It's a checklist. So I would ask that you not do that.
All right, just so counsel, my general practice is not to have that kind of list.
Yeah, I remember.
I generally don't, but I also generally will provide a copy of the instructions to each juror. So they'll have their own full copy and they can follow along, because the three of you know they're lengthy and kind of dry. So they'll have those with them. But I'll like I said, I generally don't do that chart. All right, so anything else in regards to the instructions?
No, Your Honor.
All right, so my plan would be to have at least a rough draft available for counsel tomorrow. So you at least have that. And, depending on the timing and where we go in regards to the actual closings, we'll have the opportunity for you to review those, go over the draft, and then any kind of objections or suggestions you want to make, we'll have a chance to do that. But so you'll have, again, it's a rough draft. That's all I can tell you. And nothing's in stone, but at least give you an idea kind of where I'm coming from.
Do you think, logistically, Your Honor, that with the presentation of Dr. Resnick and then the government having their 3 doctors, hopefully we finish the evidence tomorrow, we would be closing Monday?
I would expect either Monday or Tuesday. If the parties may need, we could talk about that. But, my old experience, there's been a lot of evidence and there's a lot of witnesses. And so if the parties feel that they need like a day to kind of marshal their thoughts, we could talk about that. So either probably Monday or Tuesday. We could talk about that tomorrow. All right. All right. Anything else we need to address, you think?
No, Your Honor.
All right. And so tomorrow we'll be in recess until tomorrow at 9 o'clock. Hopefully we'll start with Dr. Resnick and then, correct?
Yes.
Yeah, all right. You just kind of looked, I thought, oh. So that would be the thought, and then we'll just kind of go from there. If the defendant rests, the Commonwealth can then present their witnesses. And if it's not done by Friday, it may go into Monday, and that may mean closings and charge on Tuesday.
Okay.
All right.
And Mr. Verino will be here, yes, to set up the Zoom.
So you're not going to trust me to set that up this time? I think that's a good move.
Or me.
All right. All right. So thank you, everyone. And so we'll be in recess until tomorrow.
Thank you.
Thank you.
Court, all rise.
All right. So a little more information about what's to come. The defense does have one more witness, and it is not Patrick Clancy. It is Dr. Resnick. He is a forensic psychiatrist, and he is a nationally recognized expert on filicide, which is the murder of children, parents who kill their children, and also an expert on criminal responsibility. So he is a defense witness that's been retained to talk about specifically what's happened in this case and criminal responsibility. He has been associated with other cases known for filicide: Andrea Yates, Susan Smith, and Casey Anthony. And he is nationally known. He's a very famous expert. Cannot imagine what it must cost to bring him in, honestly. So his job was to evaluate Lindsay in connection with the lack of criminal responsibility defense. So he's not a treating clinician like the other doc was. He is somebody who evaluated Lindsay specifically around her criminal responsibility. Zeizel, already did his forensic opinion, but he actually has done treatment of Lindsay. Resnick just evaluated Lindsay for criminal responsibility for the deaths of the kids. So that should be really interesting. What does CW stand for? It stands for Commonwealth. That's the state or the prosecution. That's what Massachusetts, that's the term that Massachusetts uses, is Commonwealth. So anyway, we're going to see Dr. Resnick tomorrow. That should be very interesting and very helpful for the jury to clarify a little bit more about this case, and specifically about the defense that Lindsay is putting up. We just watched a little bit of prep for jury selection. Some pretty interesting stuff there, because the prosecution really wants to get in on the medication stuff again and really completely ignore what was found in Lindsay's blood at the time of the incident, rather than they want to focus on what was prescribed to her, not was actually in her system. And the judge actually didn't let him do it. Reddington objected to that, and the judge did not allow that. So I think that's pretty good. I think it's such a narrow view, as usual. The prosecution's view of this incident is this big. The actual incident is this big. You know what I'm saying? So narrow. Yeah, my door, I know, my front door is so squeaky. And I am so used to it, I don't think about it unless someone hears it on a live or when I'm on the phone. So did Patrick tell Lindsay she killed the children? We don't know. What happened in that exchange? And did anything happen in that exchange? Because there's been quite a bit of testimony that Lindsay couldn't speak at the time that Patrick found her. Remember, her thyroid was crushed. She had broken vertebrae and a transected spine at the time that he found her. And all we have is what he said. That's hearsay. We don't know. You know, there's a lot of other issues around that, but we don't know exactly what was said. If Patrick said that to her, if she told him she did it, like he said, the paramedics have said that she couldn't speak when they got there. So it's really tough to know exactly what happened there. She did say that right. She said the kids were in the basement. She didn't say she killed them. She said they were in the basement, according to Patrick. But then there's the phone call that Patrick and Lindsay had on Dr. Zeizel's cell phone. And what was said to her there, we don't know for sure. We still have not seen any evidence that Lindsay actual physical evidence that Lindsay did this. The idea that there is the 911 call has already been heard. It was not live streamed. So it was heard to the jury, but in the gallery, but it was not heard over the live stream. There has, however, I think we got to be very clear about, there has not ever been a confession entered into evidence in this case. And that's something that people keep saying she confessed. Did she? Where? Where is a confession? We have not seen one. There isn't one. Yeah, there are other questions about Patrick that there are still so many unknowns in this case. I still feel that we don't actually know what happened that night. We know what the prosecution wants everyone to think happened, but there's so much evidence missing to fill in the gaps about what really did happen that night. We just don't know. Right. Lindsay pleaded not guilty. She did not confess. I think that's a really, really important point. Okay, well, we're done for today. We'll be back at 9 a.m. Mountain tomorrow here on the Trials channel with Dr. Resnick, and then the defense is expected to rest. Then the state will be presenting 3 of their own doctors, and that's what I've been wondering. Where are the state's doctors? You know, there's going to be some, unless it's like LaTarsha Sanders, but apparently it isn't. They have 3 doctors. We'll see how that goes. They talked about doing closing arguments either on Monday or Tuesday, depending on what the attorneys need. Judge Sullivan is really interesting. He does not push these attorneys. He gives them time. I've seen many other judges that are like, you got the weekend, figure it out. This judge really gives everyone more time. He gives a lot of grace to everyone, including Lindsay Clancy, by this trial being shorter every day. Part of that is ADA accommodations to her. He's also being very careful with this jury to not overwhelm them. Really, really very well thought out. Yes, there will be rebuttal, 3 doctors. So I really appreciated that the judge said that out loud, because there's so much stuff we don't hear. They do a lot of things not on the live. Yeah, so we have Dr. Resnick, and then we have the state's 3 doctors. And that is expected probably to wrap up tomorrow. And then closing arguments either Monday or Tuesday. So we're down to it. This trial is almost over. I think we're all ready. This has been a really exhausting one, really emotionally heightened one for me, and I think for a lot of you as well, and obviously across the internet for everyone who's witnessed it. I do find it very interesting how many people are commenting across social media who are not watching the trial. They're commenting based on what they hear other people say or on clips they're watching, but they haven't witnessed the entire trial, and saying some of the dumbest things, some of the most ridiculous, clueless stuff. It's like everybody's got to have an opinion, but if you don't have an educated opinion about this, if you're not at least watching the trial, then what's the point? Yeah, Ashley, are you here in the chat? If you are, I don't know if you, oh, there you are. Yes, you are. What was it like, Ashley? If you can tell us in the chat, give us a little story about what it was like, because I know you were there at the demonstration this morning. I'm wearing my pink for Lindsay today. It was an amazing thing to witness. So many people there, so many women. Because we all know, don't we? We've all been through experiences like this, not to this extreme, but we've all been through experiences like this. 4 years ago, almost exactly, in 5 days, it will be 4 years since my total hysterectomy for early uterine cancer. I fought for 6 months through some absolutely ridiculous medical crap to get a diagnosis because I knew there was something wrong with me. I knew that I was having some problems. I started working with a GP first, who was terrible, frankly. I had to switch over to one of my specialists to get the referrals that I needed, who wasn't my lady doctor. I didn't actually have a gyno at the time, but I needed to get to one, and I needed some testing. And then when I got to a gynecologist, she tried to force biopsy unsedated, and I refused. And to be honest, using my skills as a social worker, I shamed the hell out of that woman for this incredibly poor level of treatment I was receiving, and finally managed to get her to agree to send in an order for me to have the test under sedation. And even that, she threw a big fit about and said, well, you don't know if your insurance will pay for it or not. And I said, well, let's give it a shot. And they did. She was very sheepish when she called me back into the office to let me know that I had very early stage uterine cancer and that I needed an immediate hysterectomy. But it was a ridiculous fight. I won't get into the entire story here because I want to tell you what Ashley has to say, but it was an absolutely ridiculous fight to get to that point, and all along I had cancer. So we have all been there in one form or another, I think. Ashley says she'd say there were at least 300 people present. She said the vibe was great, mostly women, but quite a few men. I'm really glad that there were men there. Got all excited when Reddington showed up for the day. Lindsay arrived in a van with police escort. We couldn't see her, but she saw us. Good. I'm glad. And it is well known that Reddington's wife is gathering cards of support and letters and getting flowers for Lindsay and all kinds of things from people all over the world to support her. And and that they're sharing that with her. And Reddington said that he was about to go see Lindsay and he was going to tell her all about what was happening out front for her. That's really powerful. It makes me so glad that this trial, if one good thing can come out of this horrific situation and the deaths of these 3 innocent children and the disabling of their mother, is that women's mental health, and particularly postpartum mental health, is getting the spotlight that it so desperately needs. Oh, that's funny. Ashley says, glad you are wearing pink. I didn't read the fine print and ended up wearing blue. That's all right. I think it mattered more that you were there. What a wonderful thing. So glad that you were able to be there. And you know that we were all there with you in spirit. And so you represented the squad for us today, Ashley. And thank you very much for that. All righty. I'm going to pop off from here. I will see you at 3 p.m. Mountain on our main channel, True Crime Squad, for our Thursday show today. And then we'll be back here on the Trials channel at 9 a.m. Mountain tomorrow for what is likely the final day of testimony, day 18 in the Lindsay Clancy trial. I'm Christy with True Crime Squad Trials. Thanks for being here.